Is your estate plan safe from court battles? Or can your trust actually be challenged? I'm going to explain how trust contests happen, what triggers them, and what you can do now to protect your estate from future conflict. Hi, I'm Dr. Ray Gervasio. In 30 years as an attorney, I've seen families torn apart, wealth drained, and years wasted in court, all because of poor planning. We make sure that doesn't happen. If you want to protect what you've built and keep your family out of court, call us at 408-945-3950 for that initial consultation. Let's dive in. What are trust contests in California? California law allows certain individuals to contest trusts or specific provisions within it if they believe that something was legally wrong with the way the trust was created or amended. This is called a trust contest, and while it's easy to win, and while it's not easy to win, it can cause serious delays, legal costs, and family tension. A trust contest is essentially a legal challenge. It gives heirs, beneficiaries, or other interested parties the chance to argue that the trust isn't valid, or that changes made to the trust should be thrown out. These contests are handled in probate court, and California has specific laws that govern who can file, how, and on what grounds. People who are disinherited, feel shortchanged, or suspect wrongdoing are often the ones who bring these cases forward. And in California, you have to act fast. Most trust contests must be filed within 120 days of receiving formal notice of the trust administration. If you miss that window, you may lose your chance to challenge anything at all. Grounds for trust contests in California. A trust can't be challenged just because someone's unhappy with their share. California requires that the person contesting the trust has a valid legal ground for doing so. Common causes for challenging a trust. The most common grounds include lack of capacity. The person who created or amended the trust didn't understand what they were doing at that time. Maybe they had dementia or were heavily medicated or otherwise mentally unfit to make legal decisions. If proven, this can invalidate part or all of the trust. Undue influence. This happens when someone pressures or manipulates the trustmaker into making changes that benefit them, often a caregiver, a relative, or someone in a position of control. The courts take this very seriously, especially when there's a drastic change in the estate plan late in life. Fraud. If someone tricked the trustmaker into signing documents or misinterpreted facts, that can be a valid ground to challenge the trust. Fraud can be hard to prove, but has strong consequences if successful. Duress. Similar to undue influence, but involves actual threats or coercion rather than subtle manipulation. For example, someone forcing an elderly person to sign under threat of abandonment or harm. And lastly, mistake in execution. California law has specific rules about how trusts must be executed. If the document wasn't signed properly or key procedures were skipped, the court may deem the trust or certain amendments invalid. The ripple effect of successful trust contests. If a trust contest is successful, the results can be significant. The court might throw out specific provisions of the trust, revert the trust to an earlier version, divide the estate differently than the original intent, or appoint a new trustee to manage and distribute assets. This not only delays the distribution process, but can also lead to long-term damage within families. Siblings may stop speaking, generations can feud, and what was meant to be a legacy of love becomes a source of resentment and division. That's why being proactive matters so much. Key steps in California trust contest. Understanding how a trust contest works from start to finish can help you spot weak points and protect your own plan more effectively. Here's a simplified breakdown of the process. Notification of the trust. Once a trustmaker passes away, the trustee is required to notify all heirs and beneficiaries within 60 days. This notice often starts the 120-day clock for contesting the trust, filing the petition. If someone wants to challenge the trust, they must file a petition in probate court before the deadline. This petition must lay out the legal basis for the contest. Discovery phase. Both sides collect and exchange evidence. This may include medical records, depositions, financial documents, and witness statements, court hearings, or mediation. Some cases settle through mediation. Others goes to a full court hearing where a judge hears evidence and decides whether the trust or parts of it should be upheld or invalidated. Rulings and appeal. Once a ruling is made, either side can appeal, but that adds more time, money, and emotional strain. It's worth noting that California law allows for no contest clause in trust. These clauses state that if someone contests the trust and loses, they lose their right to inherit anything at all. But for a no contest clause to hold up, it must be clear, properly drafted, and enforceable and under California's current rules. How to prevent trust contests and family disputes. The best defense is a good offense. Here are some ways you can protect your trust from future challenges. Get a capacity evaluation. If you're making or updating your trust later in life, a medical record proving you were mentally competent can go a long way in defending against future claims. Use a trust protector or corporate trustee. This adds another layer of neutrality and reduces the chance of family members accusing others of misconduct. Be transparent with loved ones. Surprises create suspicions. Even if your plan won't please everyone, explaining your reasoning now can avoid conflict later. Review and update your plan regularly. Outdated documents, vague language, or inconsistencies are all targets for contest. Consider including a no contest clause. It's not a guarantee, but it can be a powerful deterrent. And most importantly, work with a qualified estate planning attorney. DIY documents are easier to challenge and often contain mistakes. An experienced attorney can help you draft clear, legally sound documents that reflect your wishes, hold up in court, and reduce the risk of future disputes. They'll also make sure your plan complies with California law and stays updated as your life or the law changes. If you haven't started your estate planning yet, or if you need to review your existing plan, give us a call at 408-945-3950 for your initial consultation. We'll guide you through the process and help you create a plan that fits your needs. And if you found this video helpful, don't forget to hit the like and subscribe. I'll see you in the next video.